Here is a question that every person who believes in justice needs to sit with today. If a woman is charged with 6 counts of first-degree murder if she shot an unarmed mother point-blank in a school zone in broad daylight in front of witnesses, at what point does a court decide she is no longer a danger to the public? And here is a second question, just as important, when a court reverses a detention decision in a case this serious, and one of the 3 judges on that panel openly dissents, calling the decision reckless. What does that tell us about the strength of the majority's reasoning? Today we are breaking down something critical. The Illinois Appellate Court has reversed its earlier ruling and is now directing that Holly Johnson, charged with the murder of Romeca Meeks Blackmon, should be given a hearing on release conditions. 2 judges agreed. 1 judge, Justice Mitchell, stood firmly against it. But the story does not end there, because the moment that ruling dropped, the prosecution moved. The Cook County State's Attorney, Eileen O'Neill Burke, filed an emergency motion to pause to freeze the entire appellate decision. They are taking this case to the Illinois Supreme Court. In this video, you are going to learn exactly what the appellate court said to justify reversing detention, why each of those reasons deserves serious scrutiny, what the prosecution's legal strategy actually means, and how it works, and what is at stake, not just for this case, but for what it signals about how the justice system handles violent crime in Chicago. Stay with me. This is information you need. You are watching Red Rage Crime TV. If you are not yet subscribed, do it right now. Follow us on Facebook and Instagram at Red Rage Crime TV. Hit the notification bell. Let's get into it. To understand where we are, you need to understand how we got here. So let's walk the timeline. September 8, 2025. Chicago's South Loop. Just after 9 in the morning, 31-year-old Romeca Meeks Blackmon drops her 7-year-old son off at school. She has just placed a handwritten note in his lunchbox, a note that reads, "Happy Monday, son. Always remain yourself. You're the coolest, smartest, and funniest kid I know. I'll see you when you get home. Love, Mommy." She never comes home. Within minutes of that goodbye, she is shot twice at close range, once in the face, once in the thigh, by a woman named Quada Ja Johnson, known as Holly. Witnesses allege that Carlos Smith, the father of children with both women, physically restrained Romeca during the confrontation, holding her while Holly retrieved a firearm from her vehicle and returned to fire. After the shooting, witnesses say Smith and Johnson fist bumped. Romeca Meeks Blackmon, who was unarmed, was pronounced dead at Stroger Hospital. Holly Johnson was arrested at the scene and then released. She claimed self-defense. She had a concealed carry license, and for nearly 3 months, she walked free. December 4, 2025, Chicago police rearrest Holly Johnson at her home in Des Plaines. She is charged with 6 counts of first-degree murder under Illinois statute. What follows is 3 consecutive attempts by defense attorney Ari Williams to secure Holly's pretrial release, all 3 denied by Cook County Judge Michael Clancy. He cited the strength of the evidence, the school zone location, the pause between shots, the alleged fist bump, and the fact that an unarmed woman was killed at close range. The defense then appeals to the Illinois Appellate Court, 1st District. The first appellate ruling, denial. Holly stays detained. But then, April 20, 2026, the appellate court reverses course. 2 of the 3 judges vote to send the case back to the trial court for a release conditions hearing. Justice Mitchell, the dissenting judge, calls the decision reckless. And 3 days later, April 23, 2026, the state's attorney files the motion that has everyone watching. Let's go through the appellate court's reasoning point by point, because each one of these deserves scrutiny. Point 1. The court states, it is undisputed that Johnson did not seek out the confrontation. Here's the problem with that framing. Undisputed is a legal standard. That means no party has successfully challenged it in the record before the court. It does not mean it is factually true. Multiple eyewitnesses allege that Holly Johnson verbally announced she was going to shoot Romeca before retrieving her weapon. She made a deliberate trip to her vehicle. She came back. She fired. How is the initiation of a shooting where the shooter verbally telegraphed her intent considered undisputed in the defendant's favor? Point 2. The court raises Holly's pregnancy as justification for release. This is perhaps the most emotionally charged element of the ruling. The court states she needs an opportunity to prepare for birth. That is an understandable human concern. But here is what the legal system must also weigh. Holly Johnson's infant child was present in the vehicle on the day of the shooting. If the court's position is that pregnancy creates a presumption toward release, the question becomes, did the presence of that infant prevent the shooting? It did not. Pregnancy and the capacity for violence are not mutually exclusive. The courts know this, which is why using pregnancy as a primary factor in a first-degree murder detention decision raises serious questions about consistency and precedent. Point 3. The court downplays the severity of the incident, describing it as a personal dispute rather than a public threat. This is where legal analysis must be applied carefully, because the framing matters enormously. A shooting that occurs across the street from a school on a public sidewalk in front of multiple witnesses, resulting in the death of an unarmed woman being characterized as a personal matter between two individuals, minimizes the public safety dimension of the act itself. The law does not require a stranger to be the victim for a killing to represent a threat to community safety. The question is not who the victim was. The question is whether the person who pulled the trigger demonstrated a willingness to use lethal force in a public space. Point 4. The court notes that Holly possessed a valid concealed carry license. A CCL is a license to carry a firearm legally. It is not a license to use it without legal consequence. The prosecutorial argument has been consistent throughout. Even if Holly had every legal right to carry that weapon, the manner in which it was used, running to retrieve it, returning to fire multiple shots at close range at an unarmed woman, goes beyond the legal boundaries of self-defense. A license does not retroactively justify a killing. That is what a trial is for. Point 5. The court notes that Holly remained at the scene after the shooting. This point is cited as evidence of good faith and non-flight risk. But here is what the record also shows: Holly was not standing at the scene cooperating with officers. According to accounts from witnesses who were present, she was not actively engaging with police. She was making a phone call. She was in proximity. Remaining at a scene and actively cooperating with law enforcement are two different things. And more critically, the decision to remain or flee is a practical calculation. It does not speak to the underlying danger posed by the individual. Point 6. The court argues that because Holly was free for 3 months after the shooting without incident, she poses no ongoing danger. This reasoning is particularly significant and particularly troubling. The argument is essentially because the accused did not commit another crime during the period between the shooting and her arrest, she is demonstrably safe. But consider what that logic does to every future case involving a delayed arrest. If the state takes time to build a case, and the accused remains quiet during that window, does that window of behavior then become evidence of safety? This creates a perverse incentive structure where delayed prosecution inadvertently benefits defendants in detention hearings. Point 7. The court states that conditions of release can adequately address any remaining risk. Electronic monitoring, no contact orders, surrendering a firearm license. These are the types of conditions being discussed, and they may work in many cases. But the prosecution's argument, which Justice Mitchell appears to have agreed with, is that in a case involving an alleged coordinated killing, a fist bump, and a 3-month window of social media behavior showing no remorse, conditions of release require a higher degree of demonstrated reliability than this record provides. Now let's talk about what the state's attorney has actually done, because this is the most legally significant development in this case since the appellate reversal. On April 23, 2026, the Cook County State's Attorney filed a motion to stay the mandate. Under Illinois Supreme Court Rule 368C, a party can request that an appellate court stay its own ruling, while the losing party seeks review at the Illinois Supreme Court level. Here's what that means in plain language. The appellate court ruling said send this back to the trial court for a release conditions hearing. The moment that mandate takes effect, Judge Clancy's courtroom gets jurisdiction back and must begin the process of determining conditions. The state is saying, do not let that mandate take effect yet. Freeze it. Give us time to file a petition for leave to appeal with the Illinois Supreme Court and let the Supreme Court decide whether to take this case. Critically, the state did not file a petition for a hearing with the appellate court. They skipped that step entirely. They are going directly to the Supreme Court. That is a deliberate strategic choice that signals the prosecution believes this ruling involves a question of law significant enough for the highest court in Illinois to weigh in on. If the stay is granted, Holly remains in custody. The case is effectively frozen until the Supreme Court acts. If the stay is denied, the case returns to Judge Clancy. A conditions hearing happens and Holly could move toward release. But here is the deeper legal lesson in all of this. Even if Holly is released on conditions, that is not an acquittal. It is not a verdict. It is a pretrial determination. The trial still happens. The evidence still gets presented, and the prosecution still has eyewitness testimony, phone records, forensic evidence, social media posts, and a medical examiner's findings to lay before a jury. Pretrial release is not freedom. It is a temporary legal status that exists before a verdict. Here are the questions this case forces us to ask, and I want you to genuinely sit with them. If two appellate judges can look at a case involving 6 counts of first-degree murder, an unarmed victim, a school zone shooting, and multiple eyewitnesses and conclude that conditions of release are sufficient, what standard are they applying? And is that standard being applied consistently across defendants who do not share Holly Johnson's profile? If Holly Johnson is released before trial, what does that communicate to every person in Chicago who witnessed a crime, reported it, cooperated with prosecutors, and is now watching the legal process unfold? What does it say to Romeca's mother, Tina McMiller, who is raising her grandson alone, the same boy whose lunchbox note was the last thing his mother ever wrote? And what does it say about the value of a human life when the argument for releasing the person accused of taking it rests partly on the fact that she was pregnant when that same pregnancy did not stop the shooting from happening in the first place? Justice Mitchell dissented. One judge looked at the same record, the same evidence, the same arguments, and said no. That dissent matters. It is the basis on which the Illinois Supreme Court may choose to act. The prosecution has made their move. The Supreme Court will decide whether to hear it. We will be here every step of the way. If this breakdown gave you clarity on where this case stands legally and why it matters, share this video right now. Not later. Every share keeps Romeca's name alive and keeps the pressure on this case. Subscribe to Red Rage Crime TV on YouTube. Follow us on Facebook and Instagram at Red Rage Crime TV. Hit the notification bell so you are the first to know when we drop the next update. Drop your thoughts in the comments. Do you believe the Illinois Supreme Court will take this case? Do you think Holly Johnson should be released before trial? For Romeca, for her son, for every mother who deserves to come home. Red Rage Crime TV. We'll see you in the next update. Justice for Romeca.